What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we're going to be breaking down Donna Adelson's motion for new trial. And we're really going to focus on the juror interviews. So many questions always come out when jurors come out and speak. Is that actually a bad thing for our criminal justice system? Does it open up the door for arguments like this to overturn verdicts that most of the state and most of the country agree with the guilty verdicts in Donna Adelson's case? But now that the jurors have come out and spoken, is it all going to get flipped upside down? Should jurors just stay quiet? Or is this actually a good part of the criminal justice system? We're going to break that down. We're going to look at some of the arguments the defense made and see, do any of these hold weight? Will the judge overturn this and grant Donna Adelson a motion for new trial? Or is this something better for an appellate argument? And what are their chances there? All that and more on today's episode. Thanks for joining me. Make sure you guys hit that like button. Let's get into it. All right, so we are going to open up this motion here and read it together. At least parts of it. We're not going to read the entire thing because, as in a lot of motions for new trial, there are some arguments that the defense makes that are basically the same arguments they already made to the jury. And every time, even in cases that I have trials on and the other side appeals, they make the same argument that a jury completely rejected. And it is never a winning argument with a judge that's looking at it. We have to remember also this is going to Judge Everett, the same judge that did the trial. So when they're going to argue with some of the rulings that Judge Everett made, those are going to be the ones that may be better served on appeal, but you still have to make it here to protect it for appeal and be able to reserve that argument for appeal. It's all these legal rules that sometimes don't make a ton of sense, but it's how they are. So we're going to focus on some of the more interesting arguments, read most of the motion here, but not its entirety. I will mention some of the other arguments they made, certain things like the prosecution's spin on these facts is inappropriate. And you should look at it this way, Judge. It's like, that's called argument. You're allowed to do that in trial. The jury bought the prosecutor's argument. They convicted Donna Adelson. That's never going to be a reason that a motion for new trial is granted. Shouldn't say never, right? It is almost never going to be a reason that a motion for new trial is granted. But let's get into this motion specifically and see what it says. A jury convicted Ms. Adelson as charged in the indictment on September 4th, 2025. This motion is timely filed within 10 days of the rendition of the verdict pursuant to the rules 3.575 and 3.590A. Ms. Adelson requests leave to interview juror number 5 and juror number 7. So that's the first thing, right? They want a new trial. But before they even ask for a new trial, right? Because number 4 is asking for a new trial. They want to interview jurors number 5 and 7. And in Florida, we've already seen this happen in other cases. If you remember, Take Care of Maya, there was a juror interview granted in that case. So if there is enough smoke there, this is something that could actually happen. And we'll read what their arguments are and what we think the judge will do here. Ms. Adelson files this motion for new trial on the following grounds. Number 1, juror misconduct. So their number 1 argument is juror misconduct, and that's what we're going to focus on today. Number 2, verdict is contrary to the law or weight of the evidence. That's kind of re-arguing things that already lost at trial. Number 3, the court erred in a decision of any matter of law which arose during the trial. Again, that's something that might be better for appeal. Because asking this judge to overrule himself when he already made the decision in the middle of trial like days ago, again, usually not a recipe for success. And 4, for other cause not due to Ms. Adelson's fault, she did not receive a fair and impartial trial. We're going to focus on that one as well. So let's start with motion for leave to interview the jurors. In the court's preliminary instructions to the jury, the standard instruction was read. You are also not permitted to communicate about this case with anyone. Okay, let's focus on the important parts here. About this case, okay? You're not permitted to communicate about this case. Not communicate at all. Because if it said communicate at all, we'd have other issues, including, so here's where you can't communicate about this case. Your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes, so here, no communication. Now they can try to argue that this means no communication at all, but it's very clearly talking about communication about this case. Includes no in-person, telephonic, or electronic communication such as email, text messaging, or posting information on social media. We knew this was coming, or a website, or any other form of communication. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. Okay. So we know they are talking about the jury foreperson. And we reviewed her TikTok videos together. She's gone on to do other interviews just like she's entitled to do. Speak about this case publicly, especially in Florida. We are very open with our judicial process, a lot of transparency. We pride ourselves on transparency. Some people like it, some people don't. I happen to like it myself personally. But she was able to go on and share her views. And there was some mention of her posting during the trial, and I had some concerns with that. Some other people did too. Don't love it. It's really like, putting your hand really close to the stove, but not all the way on the stove. It's like, why play with fire if you don't want to get burned? I would advise anybody against that if they ever asked. She didn't, of course. So we are here now mostly because of the posting during the trial and posting on TikTok about the trial, potentially before the trial and during the trial, rather than the comments she made afterwards. But wait, we'll get to those as well. In reviewing Juror 7's TikTok account, she revealed that she posted to TikTok during the trial. We all remember that. And again, this is during the trial. In reviewing Juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. So let's talk about this comment for a second. She commented that she is a juror August 26th, 2025. Would this be considered communicating about this case? I think we're going to see some judicial discretion here because I could see it going either way. I could see a judge saying, yes, you're saying you're a juror, so you're commenting about this case. I didn't see the TikTok. I want to let the judge look at it, see how the judge breaks it down. If you guys want to send me the TikTok, I didn't go back through all of her TikToks and take a look at it, but I'm assuming this is going to be read in the light most favorable to the defense here because they're arguing that she said she was selected as a juror on August 26th. They don't say she said she was selected as a juror in Donna Adelson's case on August 26th. So is the judge going to have to infer that it's about this case? How's the judge going to look at it? A flash drive with this video will be provided to the court as the undersigned has been informed that particular TikTok was deleted by the juror from her account. So, deleted, okay? So how does this add to the interest here? Number one, if I was the state, I would argue, and I think it's a pretty good argument, that saying you're a juror is not a violation of the rules, technically, number one. And if it is a technical violation, it is completely immaterial. It does not have anything to do with how the verdict went out in this case. It doesn't mean that she was influenced by anything online. It doesn't mean she was searching anything online. So was it immaterial enough? Was it such an innocuous thing to say, I'm a juror? There are thousands of jurors picked every single day, that this is not something that we want to upend our entire judicial system by interviewing jurors for no apparent reason. She didn't say anything about the case specifically, and nothing affected her ability to be a fair and impartial juror for this case. Now, we're going to read some of the arguments and see how good that argument might be and might play with this judge. The fact that she deleted it, okay? In a lot of trials, whether it's a witness on the stand or a criminal defendant or a plaintiff in a civil case or a civil defendant, if you delete something, usually there's some form of consciousness of guilt. And if I'm the defense, I'm going to argue she knew she was wrong. She knew she shouldn't have done this, and that is why she deleted that TikTok. But judge, it was up there. It was up there during the case. And if she posted that, it's pretty likely that she was also searching about this case and interested about this case. She's putting it out there online. Her algorithm, and I don't know if they want to get an algorithmic expert, but it's like, if you start posting about true crime and being, in a trial and a juror on a trial, right as this case is exploding, do we really think the algorithm is not going to push things towards her about this trial or other trials? And she admitted to being on TikTok during the trial. How is it possible she actually didn't see anything? And that's where it opens up the door for them to try to argue they should get an interview with juror number 7. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. We'll wait till we get to some of the case law and the arguments as we get into that argument more. Now, what about juror number 5? Juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Ms. Adelson reacted to the evidence and testimony admitted during the trial. So this is actually great. I'm excited to talk about this topic as well. Let me just read this footnote. Although the jurors have identified themselves through social media or media appearances, the court previously ordered the parties to revert to the jurors by juror numbers. Okay, good. And then footnote 2 says, based on the court's numerous admonitions to Ms. Adelson during the trial, she was prohibited from expressing any emotion during the trial. Okay, so the judge expressly prohibited, and we all know, Miss Adelson from expressing her emotions. Well, juror number 5 apparently went on surviving the survivor. During his appearance, he revealed he considered how Miss Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Miss Adelson's reactions whatsoever is concerning, as her reactions are not evidence and are extrinsic or external rather than that which inheres in the verdict. As a result, the undersigned seeks to interview juror number 4 concerning his consideration of Ms. Adelson's reactions to the evidence. So we've talked about this multiple times. How do we deal with this issue as criminal defense lawyers? You don't want to be too stoic. You don't want to be not stoic enough. You don't want to cry too much. You don't want to cry too little. You can't be perfect. And we talked about this in the Karen Reed case, Kyle Rittenhouse case, Alec Murdaugh case, all these cases where the defendants have all eyes on them. The jurors are looking. Sarah Boone, a lot of cases in Florida, we talked about it as well. This is not going to win your argument, okay? This is not going to be a winning argument for the defense because jurors have eyes, they have brains, they have hearts, they have intuition, they have common sense. They're going to be looking around the courtroom. They're going to be seeing a lot of things. Just because they notice her reactions, just because they notice what color suit the defense attorney has on, just because they notice that, the lawyers or the judge or the witness is male, female, whatever their race is, whatever, right? Just because they notice those things doesn't give you the right to do an interview. And they even admit that subsequently, this juror has already stated that he obviously did not consider that during his deliberations. So we already have our answer. And this was kind of like it was in the Take Care of Maya case. If the judge were to grant an interview, we know exactly what this juror is going to say. Yes, I noticed her reactions. No, it didn't come into my mind. And you're not going to be allowed to dig into what did you say during deliberations? Did anybody take this into account or that into account? You can't get into the province of the jury and enter their minds and go through what they were debating. He said he noticed her reactions. He said it obviously did not affect his verdict. Nothing burger for juror number 5, in my opinion. I think he's already answered whatever question would be appropriate in a juror interview. I think the judge will absolutely say no to interviewing juror number 5. All right, let's get into the juror misconduct discussion now. This is the discussion of law. This is where we're really going to dig into the foreperson. According to the Florida Supreme Court, potentially harmful juror misconduct is presumptively prejudicial. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced the case. And that's where we get into my argument, if I'm the prosecutor, that this is no big deal, that this juror posted on TikTok that she's part of the jury. But according to Florida law, you don't, just to get an interview, right? To get a new trial, you have to prove that something happened to prejudice this case. But just to get a juror interview, to ask them questions, to dig into it a little bit more, you don't have to prove actual prejudice yet. Rather, it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Once improper conduct or juror misconduct is established by a juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. And that's really where I think the state's argument comes in. If they do a juror interview and the defense establishes that there is juror misconduct, then the prosecution has to say there's no reasonable possibility that the juror misconduct affected the verdict. And I actually think they would, I don't know what she would say in the interview. So if they were to call her, if they asked her, were you on TikTok every day? I mean, we know that she said mom stuff is in her algorithm, not true crime. And she didn't see anything about this case. She kind of has already answered those questions. I think maybe some people told her that could be an issue, and she's kind of tried to mitigate that issue as much as she can with these interviews that she's done post TikTok videos. She deleted it, which again isn't great, but assuming she doesn't say anything that's different from any of her other interviews, I think the state would be able to establish that there's no, and again, to say there's no possibility is kind of a high bar, but to this judge, I think the state would be able to prove that there's no reasonable possibility that the juror misconduct affected the verdict. So the fact that she posted, I'm a juror, didn't affect the verdict. I tend to agree with that, unless she says things like, yes, there was stuff in my algorithm about this case, then I think we get a new trial. If she saw if it was in her algorithm and she was seeing people post clips about this trial or their thoughts or their feelings about this trial, or people were commenting, because it really sucks that she deleted it. I would like to see the comments, or people saying like, go get Donna, make sure she's convicted. If people are commenting that on her video, that could be a very big issue and something that could actually be a reason to give Donna Adelson a new trial, which is why it's better. Technically, it might not be against the rules to post before a trial or during a trial or look at social media during a trial. It is so much wiser to stay away from it completely. If juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. So if I was the defense, I probably would have added some argument to juror number 7. And the fact that it was deleted, some of her comments that she made in other interviews to show the court that, like what I said, once you post about true crime, I would get somebody that knows something about an algorithm, put it in here, say the algorithm is going to give you what they think you want to see and what your content is about. And because I know when I started posting true crime, a lot more true crime coming in. I follow a lot more true crime people now, and legal stuff more than true crime really, but about these cases. And so I would have argued probably more that whether she wanted to or not, by posting about it, it made it a lot more likely that the algorithm was going to push these videos towards her. But they did a good job in asking for more time after the juror interview if they feel like they can make a more solid argument for juror misconduct. In my opinion, if I was the judge, I would consider a juror interview for juror number 7. I do not think Judge Everett is going to consider this. I think he is going to reject this. I think this will be denied. As far as juror number 5, I would summarily and easily deny a motion for a juror interview. He has already not corrected his statement, but given the proper context of his statement that yes, he noticed it. Evan, juror number 6, I should say, that we spoke to, said he really wasn't looking at her. Okay. But he also said that he didn't know who the criminal defendant was and who the lawyer was the first 2 days. So he's obviously looking over there. And there's nothing wrong with that. Like I said, we have eyes and we're human beings. To say that we noticed somebody over there and their reactions or what they were wearing doesn't matter if it does not affect your deliberations at all. And it's not something you considered in your deliberations. So we want people to be honest, right? We really want people to be honest. And people are going to admit what they're going to admit. And maybe we can think, yeah, right, it probably did affect it a little bit or whatever it may be. That's part of the trial. Right? That is part of the trial. And although it's not evidence, they're looking around the courtroom. Arguments aren't evidence either. Let's remember that. Arguments made by the lawyers are not evidence. Doesn't mean it's not something that you can be convinced of or consider while you're looking back there and thinking. I mean, I would argue that if a defendant is speaking out, if they're being disrespectful to the judge, that can be something the jury can consider. I would argue that. I might be wrong, but I would argue that. I would. Okay. Then we get to the verdict is contrary to the law and the weight of the evidence. This is when he's basically arguing that the prosecutor was not appropriate in how they were making their arguments. And we're going to read just a couple parts of this. At this stage, the court must make a finding that Patricia Byrd was credible before considering Ms. Adelson's alleged confession to Ms. Byrd. Under no set of circumstances can Byrd be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan is obviously not white. Okay. This is purely an argument to witness credibility that the trier of fact, which is the jury, has an instruction on how to weigh witness credibility. You can give witnesses a lot of weight, a little bit of weight, or no weight at all and reject some, all, or none of what they have to say. And again, when we talked to and we've heard jurors interviewed, they said, yes, I took it with a grain of salt. If anybody had anything to gain here, then I was like, maybe we'll see, which I loved that explanation personally from juror number 6. And that's exactly what a jury is supposed to do. So to tell the judge now to come and remove that decision from the jury and for the judge himself to say that witness is not credible is just not something that's going to happen. This is not going to be a successful argument. And then further testified again, he really goes into Byrd and goes into Bernhardt, who again, I think he did very good crosses on. And I think the jury did give them, at least some of the ones I've heard speak, a little bit less credibility than some of the other witnesses, which is appropriate and fair. And the judge isn't going to come in and say they should have been completely struck as witnesses, because if the judge wanted to strike them as witnesses, he could have. If he wanted to suppress their statements, he could have. And he already decided not to. In fact, the state's request, the court found that Miss Adelson had adopted, okay, it's another part, of the evidence that they're arguing, that Miss Adelson adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid McManawa from his own money, which he kept stapled, as confirmed by McManawa, Ryan Fitzpatrick, and June Umchinda. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Meg Benoit for the shooting until September 17th. No evidence was presented that Miss Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th, 2014. I think there's a little bit more on this. In this case, as in Ammons, there is no evidence that the defendant did some act to assist in the commission of the crime. The most that the evidence shows is that she knew of the plan at some point. That is not sufficient under the rule in Statton or Ammons. The state may argue that Miss Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the M. However, nothing about delivering money after the M could support her conviction as a principal to the M itself. Additionally, there is no evidence of what Miss Adelson agreed to pay the killers prior to the M. In fact, Meg Benoit testified during trial that the amount of payment was never addressed prior to the M. Finally, with respect to the second principle, instruction 3.5b, there is no evidence Miss Adelson made any payments prior to the M or that she, rather than Charlie, promised any payment prior to the M. At worst, even if Miss Adelson dropped cash off at Charlie's house after the M and signed the payroll checks after the M, would establish her capability as an accessory after the fact, but are not competent evidence as a principal to the first degree M. Here's what I'll say about Mr. Zellman. Good argument. That's an argument you can make to the jury. The state can respond with the argument that, based on the conversation they had after the fact, referencing that it deals with the two of them, based on the fact that she knew where to go, what to bring, what time to bring it, the license plate written in the planner. Again, these are the state's arguments, okay, if you take them as true, that she set up the TV repairman, that they talked about the TV, that they planned a party for Harvey's birthday, all the stuff the state threw out there, some of which you can agree with, some of which you might not agree with. All of that doesn't matter now because the defense, I actually think Zellman made a better argument here than was made in closing argument, but they had the opportunity to make this argument. The state had the opportunity to make their argument. Both arguments were made based on the evidence and the facts presented, which I don't remember every single word and how it was said in the trial. The lawyers may have a transcript by now. I doubt it. It never really comes out within 10 days, but they're making an argument based on their memory of the facts. The point is the jury heard the facts. The jury heard both arguments. The jury made the decision. In America, we want to protect jury verdicts. The judge is not going to say, I'm going to completely disagree with the jury who heard this argument, heard the state's argument, bought the state's argument, agreed with the state's view of the evidence, and convicted Miss Adelson. I'm going to throw that out and I'm going to agree with the defense. That's not what judges should do. That is absolutely not what judges should do. I don't think that's what this judge is going to do. All right, now on conspiracy, again, they make the argument that there was no direct evidence. This is an argument that has never, I've said never so many times during this, and I say I really shouldn't, but that is an argument that should not win because we all know that while direct evidence is best, I should say direct evidence is best. Maybe not everybody agrees with me on that. Circumstantial evidence can absolutely be enough to convict somebody beyond a reasonable doubt. So that argument they made in front of the jury, it lost. They continue to make it here in front of the judge. The undersigned asks the court to consider the evidence without the state's spin placed on it, also known as argument. Certainly, Miss Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. That craziness that she did spew in those motions and text messages and emails, that the jury is allowed to look at that and say, this is where she's willing to go. Where is her line? Does she have a line? They're able to consider that, right? And make inferences from that evidence. Once the dissolution was final on July 31st, 2013, what evidence exists that Miss Adelson continued to have a motive for Mr. Markel to be out of the picture? Well, it's the only way if you listen to Jeff Lacoste. The only way they could get it is if something happened to Dan. And right after something did happen to Dan, what happened to the kids? Boom, the motive was secured. They got the kids down in South Florida, changed their names, and got everything they wanted. So the motive, I think it's fair that a jury said the motive still continued. If we ignore the emails where she suggested her daughter ensure Mr. Markel be obligated to share expenses with her for their son's college education, etc., all events which would necessarily take place after he was killed, there is none. It's like, so if we throw out some evidence, there's none. Where is the evidence that Miss Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. Again, taking away some text messages, conversation. Just because the conversations happened after the fact doesn't mean they don't reference anything before or could prove something that happened before. That would be like me today saying, "Oh, that was so awesome what we did 2 weeks ago," and to be like, "Well, that conversation happened after, so we can't use it against them for what happened 2 weeks ago." A lot of the same arguments here. Okay, now we're going to get to some of the judge's decisions during trial and whether or not any of these are going to be good arguments for a motion for new trial or on appeal. The court erred in denying Ms. Adelson's request to admit into evidence the complete 2014 and 2023 planner. During the trial, the defense sought to admit the complete planners to correct the misrepresentations expected to be made by the state and which came to fruition during the state's closing argument. The state argued that Mr. Markel's tag number in the 2014 planner was evidence Ms. Adelson provided the tag number to the shooters, despite there being no evidence this happened. That would be an argument based on the evidence. Rivera testified that there were words on the paper given to Garcia, but no evidence was offered as to what those words were. With the 2023 planner, the state argued the planner indicated in anticipation of fleeing the country that Ms. Adelson was selling personal items. Admission of the complete planner would have corrected the misrepresentations by the state, as there were 39 other entries in the planner where Ms. Adelson also listed to sell identical items as far back as January of 23. In Curtis v. State, the court recognized judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. As the court admitted portions of both planners, there is no question concerning the authenticity of the materials. Exclusion of the planners infringed on Ms. Adelson's right to present a defense, and the evidence was important to defeat the argument that the state was fleeing to avoid prosecution. That she was fleeing, sorry. Thus, the court erred in excluding the planners as evidence. So here's what I'll say. I don't know exactly what is in all these entries because we didn't get to see them. But if there really was some evidence in the planners to combat that she was selling items to flee, or that there were other things that make the license plate or tag number more innocuous, that could be a big error by the judge, because I think those were important arguments for the state, especially the tag, because it was before, and why would she have that? And she must have been in on it and giving it. I think that was a really big piece of evidence that they found and was kind of new during this trial. So if there was other things in this planner, I think the judge should have let it in. Also, if there was 39 specific entries that the defense could have pulled out, which I don't know that they were prepared at that point to pull them out. Maybe they were. I think they should have been presented to the jury to show she didn't just sell stuff to leave. She was going to sell stuff much earlier in the year as well. That doesn't necessarily mean the entire planner would come in. So my memory is they asked for the entire planner to come in, which I can understand why the judge might not want irrelevant evidence to come in. But if they could have picked out very specific relevant portions, I think that should have come in. So there's some nuance to this argument. I don't think it's going to be enough for Judge Everett, but we'll see on appeal if it becomes a big issue for them. Okay, next, she didn't receive a fair and impartial trial. It goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and the United States constitutions. The Due Process Clause of the 14th Amendment guarantees the right of state criminal defendants to be tried by an impartial jury. The 14th Amendment incorporates the essence of the 6th Amendment right to be tried by a panel of impartial, indifferent jurors, whose verdict must be based upon the evidence developed at the trial. As Chief Justice Warren was observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusion of facts into the trial process that tend to subvert its purpose. Specifically, the courts must vigilantly guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all the forms of trial conformed to the requirements of law. So you can see where this is going here. The court explained in Schutz v. State that the presence of courtroom observers wearing uniforms, insignia, buttons, or other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute a denial of the accused's right to a fair trial. So you're allowed to wear certain things, but it can rise to a level where it does impinge on your right to a fair trial. What is that line? Let's see if they tell us. However, there are situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. When such a claim is raised, a case-by-case approach is required to allow courts to consider the totality of the circumstances. A defendant claiming she was denied a fair trial must show either actual or inherent prejudice. Actual prejudice requires some indication or articulation by a jury, juror, or jurors that they were conscious of some prejudicial effect. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. So this was something that I didn't see asked to any of the jurors. And I wonder if you guys have seen any other clips or interviews from any of the jurors that they were asked if anything happening in the courtroom caused them some kind of prejudice or caused them to feel a certain way or lean a certain way, or they considered anything happening with the observers in the courtroom. That would be an interesting question for those jurors. I didn't hear any of it. So that's number one. But another one is if you show by the defendant that it was an unacceptable risk of impermissible factors coming into play. This is a case where the cumulative effect of the number of factors constitute inherent prejudice resulting in Ms. Adelson's not receiving a fair trial. So I think this is going to be more number two versus they have some reason to think that the jury was actually prejudiced. When the court would rule against the defendant, on many occasions, the members of the gallery supporting the state would laugh out loud. So we did hear some of the jurors say, yeah, the judge maybe went at the defense a little bit harder or whatever it may be. That's very common across courtrooms across the country. I was just talking with, I'm at a lawyer conference right now, Florida Justice Association conference, had dinner with some lawyers last night. And they were talking about how, they've been in cases where, in criminal cases, especially where the judge is just like, oh yeah, with the state, and then hammering the defense on everything, which again is not uncommon. Anybody that's tried a lot of criminal cases knows that and has felt that. Even when you're prosecuting cases, you feel it, the good side. Counsel for the defendant brought this to the attention of the court, and the court would appropriately advise the gallery that this was not acceptable. The court did this on more than one occasion. So are they going to try to use that? The court already agreed this was happening and had to step in. It rose to the level of being prejudicial. However, the conduct continued throughout the trial, and the court took no action to remove those who violated this order. So we did hear this mentioned multiple times, and the judge would kind of threaten to take people out. I wasn't there. This is maybe a question for some people in the courtroom. How bad was it? Most people support Dan Markel in that courtroom. So I'm assuming most of them are going to say, oh, it was no big deal. This is not something that really should be prejudicial. I don't know. This undermined the credibility of the defense in the eyes of the jurors. So Tim Jansen's a criminal lawyer in Tallahassee, was a former federal prosecutor. We had him on our podcast. He goes on STS all the time. He was in the courtroom, I believe, at least a couple of days. He knows what the atmosphere is like in the courtroom. And even though he may support the Markel side, I don't even know, right? Specifically, I haven't talked to him that much about it outside of our conversation on the podcast. But I'd be interested in his take on, does he think this rose to any level to even be a real argument, or is this completely grasping at straws? I'd be interested in his take on that. Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. If this is true, it's a huge deal. It's a big deal. And this is something that maybe Tim Jansen or other people sitting in the gallery wouldn't have noticed. Because if it's somebody next to you or behind you, you might not see that. If this is true, and there's actually video capturing this or picture and capturing this, you better attach it to this motion, give it to the judge, let the judge look at it. And if they really are making faces where they're in obvious view of the jury, that could be a problem. And I would hate that as a criminal defense lawyer if that happened to me. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. Now, can you say that without a juror telling you that's true? Not really. That's not going to be a very winning argument if none of the jurors agree with you. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. So I remember most of them being outside the presence of the jury, outside after the verdict was read, but maybe some happened in the presence of the jury as well. But I feel like I remember most of that happening when the jury was outside the courtroom. The law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in this case may cause the jury to believe the defendant had no care or concern for what the victim endured. So again, I think they're kind of making a little bit of a leap. That even if the jurors did say they noticed her reactions, they didn't necessarily say this is what it made them think. So they're making arguments on facts not in evidence, basically at this point. But they're trying to say it was so bad, it doesn't matter whether a juror says it affected them or not. It obviously did. That's what they're basically trying to say. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. She did become tearful during her first sight of the autopsy photos and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out. She did need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. So here's what I'll say. If the court is admonishing my client, telling my client to not show emotion, telling my client to be quiet, whatever it might be, and I didn't feel like my client was doing that, that's an argument I would have with the judge. And I would say, Judge, she's not a robot. She might cry. She might cover her mouth, whatever it may be as a natural reaction. I will tell her to make sure it's not overboard or that she's not pushing any boundaries and that she remains as calm as possible. And if we need a break, to take a break. But I'm not going to tell her to be a robot. You don't have to. The judge can't force you to tell her to be a robot. And then if the judge does start going off on your client in front of the jury, that's a major problem. And judges usually don't do that. I don't think Judge Everett would have done that. So I would push back if I truly believe this in the trial. I don't remember a lot of pushback unless it happened at sidebar. We got to remember we didn't hear what was happening at sidebar, and a lot of arguments happened during sidebar. So I'm not condemning these lawyers for not making certain arguments, but I would have absolutely made that argument if, again, I wasn't in the courtroom, so I don't know how loud she was gasping or if she really was being a distraction. He's saying she didn't. So if he believes she was not, that's an argument he should make to the judge while the judge is admonishing her, like, Judge, chill. She's a human being. She needs to react appropriately to how she feels because we all know the jurors are watching. And I'm not going to tell her to overreact or underreact. She's going to react how she is without becoming a distraction or doing anything inappropriate. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. This impacted the decision of the jury, resulting in Miss Adelson's not receiving a fair trial. So he's basing that off of the fact that the jurors said they did notice her reactions. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Ms. Adelson decide whether she would testify. We knew this was coming. Both counsel for Ms. Adelson as well as Ms. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial in order to make a knowing and intelligent decision. We knew those words were coming. Knowing and intelligent decision is what was probably the most important decision of her life. This was especially significant in that the state made numerous changes to the evidence during trial. And I think that's actually true. And they brought in some things and were asked some things that some discovery violations. So I kind of agree with them there. When the court recessed early on September 2nd to allow counsel to meet with Ms. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so that we could discuss them with Ms. Adelson. Counsel then drove to the detention center to meet with Ms. Adelson for 2 hours, authorized, arriving at approximately 5 p.m. Counsel did not have enough time to go through every exhibit with Ms. Adelson during this meeting. Counsel advised that the court of this fact the following day when the court inquired about Ms. Adelson's decision. Not only did the court force the defendant, force is big, right? Is it knowing and voluntary, or is it coerced or forced the defendant to make an uninformed? Is it an intelligent waiver of its uninformed decision? He threatened to hold, threaten, again, can't be made by threat or force or coercion, to hold counsel for the defendant in contempt of court because they were continuing to speak to their client about this important decision that she had to make, which again brought an audible derogatory response from the gallery. Okay. This paragraph 70 is a problem. Do I think Judge Everett is going to give her a new trial because of this? Obviously not. He already heard these arguments. He already made his decision, but this is something we knew was coming. And the fact that it was on day 2 and they asked for 4 to 5 days shows they had time. They should have been able to take an hour and a half or 2 hours, in my opinion, to discuss it with their client. I realized they had the day before. I don't think everybody's going to agree with me on this. I have talked to a lot of people who do agree with me and say this is going to be an issue. Even some judges have reached out to me. But at this point, I don't think Everett is going to go for this. I think this is going to be denied, but I think this is going to be their number one appellate argument. Oddly enough, whenever the state needed additional time to set up electronics for opening statement, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them the additional time, he joked with the prosecutors about it. So we talked about how the fact that they got additional time in their closing argument, whoa, that was a horrible highlight. In their closing argument. While I agree, I think this is a good argument to make by the defense. It's totally different, right? Asking for 5 or 10 minutes to set up the podium, asking for 5 or 10 minutes here or there. If I was the defense, I would have objected to more time in closing argument. Like I said during that, we don't have to rehash all of that. But this is not the same as what they asked for. This is also nowhere near as important as what they were trying to discuss. Okay. So the fact that, you need 5 minutes for closing argument or to move a podium around is nowhere near as important as will the defendant testify in her own defense, thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude its closing argument. It was also a lot more time that they were requesting. The defendant's request was not granted and made a huge impact on the outcome of the case. The court showed favoritism to the state at most every juncture of this trial. The judge is not, I'm terrible at this. The judge is not going to like this. I don't think it's going to affect his decision. I think he's still going to be fair. I think he's still going to be impartial. I think he kind of knew this was coming. And again, a lot of judges know criminal defense attorneys sometimes feel like this. Sometimes it's warranted. Sometimes it's not. Some cases are much worse than others. I felt like Judge Everett was very fair to both sides, but I do feel like there were a few times where he got annoyed or frustrated with the defense, and some of that even came out in front of the jury. Outside of that, I think he was very fair with his rulings. I agreed with the vast majority of them, even the ones I disagreed with. I understand where he got there. I think he was pretty kind and patient with both sides. But again, you also have to understand these prosecutors try so many cases in front of the same judges. Criminal defense attorneys are going in front of all these different judges all the time. So a lot of times you build rapport with different judges. There are friendships outside the courtroom as well, but that shouldn't, and I don't think it did, affect any of his legal decisions in this case, which is important. But I understand why the defense felt like he was mean to us and nice to them. While the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its tasks over the lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. This is something that might be used in an ineffective assistance of counsel claim, right? A lot of these arguments, I think, are setting up for some of their better arguments in appeal. I don't think they're going to win the fact that Judge Everett was biased and showed favoritism. I don't think that's going to be a winning argument, but were they given enough time? Was Donna given enough time to make that decision? The court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Additionally, even when the court sustained a defense objection at sidebar, when the defense sidebar was concluded, the court announced to the jury that the objection was overruled. I didn't think that was necessarily a big deal at the time, but if they can go back and actually show that this was not done in an even-handed nature, that could be a problem. During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering the court's question. We weren't there for the sidebar, so no comment. If that's true, that's not great. The defense lawyer needs to be able to make their argument on the record. They shouldn't interrupt the judge, but they should always be given the opportunity to make their record, even if they lose, even if they're wrong. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on the part of the court to not only the defense, but spectators in the gallery, the media, and those viewing the trial through the media. Interesting. I wonder if they're going to pull any clips or views from other people thinking that. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed toward Miss Adelson and her counsel in the case. So it's like generally everybody loves Judge Everett, but he was worse in this case than many other cases. That's interesting. I have no comment there. I've never tried another case in front of Judge Everett. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome over another, and that was read in this case, it is not realistic that a jury can set those feelings aside. If you say that as a lawyer, sometimes you get into a sticky situation because it's like, why make these instructions to the jury if you're like, obviously they're going to disregard these instructions? And if you're the court, you're like, all of this was cured by that instruction. Even if I did say something, everybody's going to know not to consider that because we tell them not to consider it. The totality of the circumstances present during Miss Adelson's trial established inherent prejudice, to wit, there was an unacceptable risk of impermissible factors coming into play. So they asked this court to grant this motion. It's an interesting motion, right? Especially the stuff that has to do with the jury. And I would say the three most interesting things to me are juror number 7 posting on social media during the trial and being on social media during the trial and after. Donna Adelson's ability to make a knowing and intelligent waiver of a Fifth Amendment right to testify or not testify, and the courtroom atmosphere, right? The gallery, the judge, the sidebars. Was it even-handed? Was it not? Those are the three things that interest me most when they go forward. Now, will the judge give a jury interview? Probably not. I think the judge is going to deny all of this. If he grants anything, I think it's an interview of juror number 7. But how will the appellate court look at this? Because I think usually appeals have little to no chance. I would say this one's closer to the little side than the no chance side, which is on the better side of appeals, because there are some really interesting issues here. And we'll see what lawyer they hire. That could make a difference as well. Will there be some ineffective assistance of counsel claims? I think they kind of maybe gave a precursor to some. So we'll kind of see how that goes. Let me know what you guys think in the comments. Do you think any of these arguments hold water? Do you think any of these arguments will be better for appeal? Do you think Judge Everett will consider any of these arguments? I tend to think not, since he's already made the decision on most of them. And all the factual arguments, those have little to no chance because the jury was the fact finder and they already found the facts in this case. So I appreciate you guys so much for coming to hang out. Hopefully you hit that like button. Hopefully you're subscribed. I'll be at a conference all week, so I'll be doing videos when I have time. Please let me know what you're interested in. So many of you sent me this and had questions on this. Love to break it down. Love to talk to you guys about what you're interested in. Love to be here, hanging out with you guys, being able to do this. It's an absolute joy in my life now that I never knew I needed. But now I'm so happy to be here. So thank you guys so much for everything you do and everything you say here. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.